Good morning, Mr. John, and I'm going to discuss about the background of the dispute. So, a case study of the South China Sea arbitration has a significant importance on an international context. The case was opened between two renowned countries. One is the Republic of the Philippines, and the second one is the People's Republic of China. The case was filed in permanent court of arbitration under the 1982 United Nations Conventions on the Law of Sea or UNCLOS. Above mentioned case is wholly related to the disputes of two parties related to legal issues of maritime rights and engagement. The scenario of current and geographical characteristics and the legislation of present actions all are taken by China in the South China Sea. These are four notable issues which were raised by the Philippines. The first one was to solve the problems of the parties related to the source of maritime rights and engagements in the South China Sea. The second one, the second one was a the two relevant parties were concerned with the engagement of maritime areas which are operated by the Convention of Scarborough Shoal and particular maritime characteristics in the Spratly Islands, which are demanded by China and the Philippines. The third one was a long series of disputes where distressed the legislation of China's legal actions in the South China Sea. They were interfering with Philippines' rights and regulations, and they were absolutely failed to guard and preserve the marine environment. Lastly was China has enlarged the problems between themselves by protecting access to the remoteness of Philippines Mariners Station at Second Thomas Shoal. At the same time, China had made an announcement in 2006 in order to eradicate maritime boundary border from the embracement of a particular dispute settlement. China did not agree on this matter.
This is Elaine Wee. I'm going to talk about the legal issues and individual parties' argument of the South China Sea arbitration. The Philippines filed a case against China for violating the UNCLOS guidelines and its demand to expand the historic rights of the Nine-Dash Line, which China did not have on the map. According to the law, China must have their own maritime zone, but they did not follow the guidelines and made an illegal entrance on the Philippines zone. At its most basic level, this is a contest between China and several Southeast Asian nations over territorial control in the South China Sea, which includes some of the most strategically important maritime territory on Earth. The individual parties' argument. On 23rd of January 2013, Philippines announced that it initiated an arbitration case against China by issuing a notification and statement of claim in accordance with the dispute settlement provision of UNCLOS. However, China raised 4 points against the arbitral tribunal. First, the sectional and total refusal of the arbitration procedure and the ruling of the tribunal is considered as illegal and illegitimate. Second, the mentioned remark has suggested that not only the procedure of arbitration rely entirely on the US, but they forced Beijing and other relevant countries to accept their leadership, which will destroy the regional order and Sino-US relation. Third, according to the belief of China, there would be no existence of the third party and either UNCLOS based or other sole judgment regarding the particular context of geography. Lastly, this case has a positive side as well. The dictator and non-authoritarian Chinese sources have said that as there is no presence of the third party, Beijing has the full right to guide the use of the peaceful negotiated procedure in the matter of the SCS problems.
This is Deniz Bakırcıoğlu. Today I'm going to talk about tribunal's decision and importance of the case in international law. After a lot of controversies, the court has reached its final decision. Article 9 of Annex 70 UN clause has said that if a nation of the problem never appears before the arbitral jurisdiction or unable to provide relevant proof of the case, the jurisdiction must counter itself. It must provide relevant guidelines and defending facts. There are several articles which lie in Part 15 of Convention, which deals with the elaboration and proper use of Convention. By following these guidelines, the matter of dispute may be solved. Part 15 of the Convention holds different provisions which particularly express the perfect usage of the current process. Section 1 of the thesis Part 15 states that parties who have international disputes, they both have some obligation to meet up their disputes peacefully and according to their own choices. According to the government of Philippines, China had violated the laws and regulations, and they had sought to work in a violent manner that could reach harm the vessels of the Philippines.